Let's talk legal matters now. Bhekumuzi Mike Sandlana, that's a leader of a faction of the International Pentecostal Holiness Church. He's back in the Pretoria Specialised Commercial Crimes Court today for judgment on his bail application. Sandlana is accused of attempting to bribe Pretoria High Court Judge Portia Phahlane in order to secure a favourable outcome in the long-running leadership succession battle within his church. The outcome of his bail is currently being delivered. Let's listen in.
IPHC between one Frederick Leonard Huizimang Modise, Tshepiso Modise, both being applicants, and first defendant being the applicant here in accused number 5, Mr. Bhekumuzi Mike Sandlana. It is further alleged as a basis of the corruption matters that accused number 4, who is a co-accused to the applicant, Ms. Portia Phahlane, accepted a series of gratifications from Mr. Sandlana to decide the succession battle as aforementioned in his favour under case number 11935/2016 and 14038/2019, which were consolidated as I have been informed. May I plead with the parties herein and other interested parties not to allow me not to belabor this judgment due to time constraints and not to reiterate each and every aspect of the evidence placed on record in this application, as every important evidence from Exhibit A to Exhibit D and their respective annexures were duly read into the record of court. I will refer to the relevant portions of the said evidence wherever it is found to be relevant for the adjudication and decision-making expected of this court. Since the court and the parties agreed that Schedule 5 of the Criminal Procedure Act is applicable due to the amounts wherever they are in excess of 500,000 rands or in some instances 100,000 rands, as the charge sheet indicates, and an element of common purpose being alleged, the court duly appraised the applicant, Mr. Sandlana, of the provisions of Section 1611, small b in brackets, and Section 6011, capital B, subsections A to D of the Criminal Procedure Act. Section 6011, small b in brackets of the Criminal Procedure Act provides as follows. In subsection small b, referred to in Schedule 5, but not in Schedule 6, the court shall order that the accused be detained in custody until he or she is dealt with in accordance with the law, unless the accused, having been given a reasonable opportunity to do so, adduces evidence which satisfies the court that the interest of justice permit his or her release. As to how the court satisfies itself that the interest of justice permits the release of the applicant, further provisions to be considered under Section 60, which are to be read with Section 64, A to E, are subsections 5, 6, 7, 8, 8, capital A, 9 and 10 of the Criminal Procedure Act. Regarding the consideration in the interest of justice, the following thus is crucial to consider. To start with Section 60, subsection 4 of the interest of Section 60, subsection 4, which provides that the interest of justice do not permit the release from detention of an accused where one or more of the following grounds are established. A, where there is a likelihood that the accused, if he or she were released on bail, will endanger the safety of the public or any person against whom the offence in question was allegedly committed, or any other particular person, or will commit a Schedule 1 offence. B, where there is a likelihood that the accused, if he or she were released on bail, will attempt to evade his or her trial. Or C, where there is a likelihood that the accused, if he or she were released on bail, will attempt to influence or intimidate witnesses or to conceal or destroy evidence. Or D, where there is the likelihood that the accused, if he or she were released on bail, will undermine or jeopardize the objectives or the proper functioning of the criminal justice system, including the bail system. Or lastly, E, where in exceptional circumstances there is the likelihood that the release of the accused will disturb the public order or undermine the public peace or security. The factors which are relevant to the matter before court will be considered later in this judgment. In considering a bail application, it is advisable to take into account the following citation from the decision of the consolidated cases of State versus Dlamini, State versus Kladla, State versus Jube, and State versus Skitakat, with reference 1999, volume 2, SACR, page 51, CC in brackets. And I quote, open quote, bail proceedings are sui generis. The state is thus not obliged in its turn to produce evidence in the true sense. It is not bound by the same formality. The court may take into account whatever information is placed before it in order to form what is essentially an opinion or value judgment of what an uncertain future must predict. To do this, it must necessarily have regard to whatever is put up by the state in order to decide whether the accused has discharged the onus. Close quote. In exercising a judicial discretion, a court must consider also the totality of the evidence and decide the matter on probabilities. I here inside the decision of State versus Diale and another. It's a 2013 volume 2 SACR on page 85, Gauteng North Division at paragraph 14. The grounds for the bail application brought by the applicant. The applicant's affidavit sets out his personal circumstances. I refer here into Exhibit A, his founding affidavit, and to somewhat an extent Exhibit D, his replying affidavit. Before that, it is just prudent to summarize what is contained as personal particulars of the applicant as indicated in Exhibit A. In summary, that he was born in Middle and Soweto. He does not have previous convictions as they had been expunged, and he's married by civil rights to one Phahlane Benedicta Sandlana, and these parties are engaged in a divorce, as the court was informed, and the applicant is married to other 4 wives through church custom. He has got 9 children, 6 of which are adults, and 3 minors aged 6, 4, and 3, respectively. The applicant's maintenance in respect of the aforesaid estranged wife is 10,000 rands per month, and in respect of 2 of the children, the minor children, 2,000 rands each, and the one maintained at 4,000 rands per month. The applicant also deposed to the fact that he is a pastor, comforter of the church, as being abbreviated, and he oversees charitable projects, and he also funds students in as far as education is concerned. That he is funding 22 students in Russia, as indicated in Exhibit A, and he also accompanied them in 2025 August. He also operates from the Michael Sandlana NGO that provides, this is a foundation that provides many other issues in running the projects in the community, not only in South Africa, but also including the SADC countries. And To that end, the court was also shown a document annexed to before court of the projects that he assists the community with, that is housing, food parcels, and other necessities that may be needed by the community. The document to mention of essence is that on the picture that is depicted or placed on record, the picture shows that it was obtained on the 5th of December 2025. The health of the applicant also is deposed to outline that he has got a life-threatening asthma, shortness of breath that needs immediate attention whenever he would have been attacked. He also indicated that he has got lumbar or spine pain. And the other factors, as I said, I do not want to belabor the record unnecessarily, as all of them were read into record. There is a reason why I pointed out the ones before court. But in a nutshell, in the affidavit, he denies the allegations as placed against him, indicating that he had not at the time been furnished with a charge sheet to can in more information or a response that is fully placed before court. In respect of what I've mentioned on the grounds for the bail application, yes, the applicant's affidavit Exhibit A and Exhibit D, which is the responding affidavit, are relevant herein. The argument submitted by Advocate Meyring on behalf of the applicant, as well as a summary of what was placed before me as indicated earlier. I will concise the factors and apply them to the relevant provisions as follows. A, in terms of Section 60, subsection 5, now dealing with what I should look at as factors to adjudicate and which would assist in the decision-making of this court. Under subsection 4A, in considering whether the grounds in subsection 4A have been established, the court may, where applicable, take into account the following factors, namely A, the degree of violence towards other implicit in the charge against the accused, and B, any threats of violence which the accused may have made to a person against whom the offense in question was allegedly committed or any other person, and C, any resentment the accused is alleged to harbor against the person against whom the offense in question was allegedly committed or any other person, and D, any disposition to violence on the part of the accused as is evident from his or her past conduct. E, any disposition of the accused to commit Roman figure 1 offenses referred to in Schedule 1 Roman figure 2, that is an offense against any person in a domestic relationship as defined in Section 1 of the Domestic Violence Act of 1998, or Roman figure 3, an offense referred to in AA, Section 17.1 of the Domestic Violence Act of 1998, Section 18.1A of the Protection from Harassment Act of 2011, or CC, any law that criminalizes a contravention of any prohibition, condition, obligation, or order which was issued by a court to protect the person against whom the offense in question was allegedly committed from the accused, as is evident from his or her past conduct, and F, the prevalence of a particular type of offense, and G, any evidence that the accused previously committed an offense, Roman figure 1, referred to in Schedule 1, Roman figure 2, against any person in a domestic relationship as defined in Section 1 of the Domestic Violence Act as aforementioned, or under the Harassment Act of 2011. And under H, any other factor which in the opinion of the court should be taken into account. Secondly, about the applicant's estranged wife's evidence, being that since that matter of the fraud against the applicant in Court 8, Regional Court, Pretoria, had started, she was attending court and came to testify until she was placed under witness protection. In this regard, the defense argues that if there was substance in the alleged threats leveled against the estranged wife of the applicant's bail could have been cancelled. And further, mention was made of the witness Papi Maluleka, similarly according to the defense, who was not threatened with killing as alleged by the investigating officer, a Lieutenant Colonel Schnell, in Exhibit B. And further that Mr. Maluleka was not chased away from the church, but that he was reported by the Johannesburg bar in respect of the allegations to the LPC, and further that the state deliberately revealed the identity of some of the state witnesses in the charge sheet. And in respect of the affidavit of Mr. Tshepo Phuthi, who is accused number 1 in this matter, the applicant denies his evidence as indicated in that affidavit in respect of the alleged threats, and argues that the applicant is just protecting himself as he's an accomplice to the matters that he's also facing. In respect of the matter that also was brought before this court, in the evidence presented is the Zirbekom matter, where the applicant and his or other church members is said to have acted violently, and the argument being presented being that the matter was ultimately struck off the court's roll as the state didn't have its housing order, and it was turned into an inquest inquiry. The defense referred to a fraudulent application brought in the Western Cape High Court, where a fraudulent order was ultimately reversed, and further that to bring the application that the applicant did in the High Court against Ms. Mabelane, his estranged wife, was not to intimidate her as alleged, and Mabelane admitted to have provided the court with incorrect evidence. The state, on the other hand, through Exhibit B, page 3, paragraph 6, makes reference to the evidence of accused number 1 in this matter, Mr. Tshepo Phuthi's affidavit that he himself published in the Sunday Times newspaper on the 30th of November 2025. Exhibit B, annexure LRS1, is referred to in particular, paragraph 36 thereof. It is alleged from this paragraph that since Mr. Tshepo Phuthi's involvement in a bitter civil dispute, he has been chased away from the church and has been in hiding since June 2025, as his life has been threatened. The reason, based on the content of the affidavit of Mr. Tshepo Phuthi for publishing this, is that his secret would not go to the grave with him, and he is under threat of being killed, as he knows a lot of negative information about the unlawful activities of the applicant. The defense in this regard indicates that the court should not believe the version of Mr. Phuthi as an accomplice or being also involved in the matter before court, as he is protecting himself against the allegations and the charges. Mr. Phuthi on page 36 avers that there is a strong relationship between the South African Police Services and the applicant. And the latter, that is, the applicant, has excessive networking kind of relationships with them in different government departments, and some form part of Sandlana's security protection. An argument that Mr. Phuthi could have reported to the police in the mind and view of the court should then be evaluated with the utmost caution as to whether he would have been expected to report the same level threats after having mentioned in his affidavit that some of the South African Police Service officers or members are in cahoots or have this networking relationship with the applicant. before court. The applicant, in respect of Mr. Puti's allegations, merely barely denies, as indicated, and has given a reason that Mr. Puti has just acted likewise to publicize the affidavit himself. Mr. Puti indicated as well in that affidavit that he acted on instructions of the applicant in many instances as a director of the company Songo Pty Ltd, which is registered in the names of the applicant before court and owned by him, and that the applicant leveled threats against him about his activities. The defense argued on behalf of the applicant vehemently against the Albertine case as alleged in Exhibit B, page 177, as based on Constable Mposa's affidavit, that is on page 176, paragraph 9, and that it should not be regarded as a pending matter, and in that regard referred this court to the decision of State versus Mothuani. It's a case A73/2025 JHC at 1222, decided by Bokako AJ on the 20th of November 2025, where it was held that the likelihood of committing other Schedule I offenses should not be evaluated to say that the existence of pending charges should be proof of a future propensity to commit crime. The first argument placed is that in respect of the Albertine case, as defense argued, the accused has not been charged on that matter and it has not been presented before court. The state referred to the fraud count in the Court 8 Regional Court, Pretoria, the matter that is still pending, and argued that the applicant herein is downplaying his role playing in the evidence presented before that court, in the sense that he is suggesting that the case of the state is either weak or non-existent. It has been submitted that the state has already closed its case in that matter, and argument should be presented before the presiding officer to decide as to whether he would acquit or not the applicant and others who are appearing with him. The allegations in the matter as presented and documents have been presented before this court is that a fraudulent letter of executorship in respect of a deceased who is the very same estranged wife of the applicant, Ms. Madalane, that fraudulent letter of executorship in respect of her, and it has been as such created during the time when she is still alive, and it was obtained in the names of the applicant, meaning that the applicant is the executor of the said alleged estate. And based on the misrepresentations, as I have been alluded to the Department of Home Affairs, the letter of executorship is being presented to the Master of the High Court through such misrepresentation that Magwelani is deceased. The benefit would be a payout from the insurance at the tune of around 4 million rands, and the state argued that the case for the state cannot be downplayed to be weak or to be non-existent in as far as those the scenario is being outlined to the court, that the person to benefit is Mr. Sandlana per se, the applicant before court. It has been held in a variety of decisions that a breach of a normal condition of bail to commit other offenses whilst so released on bail should be regarded by courts as a very serious breach and disregard of authority and the criminal justice system, including the bail system. To say that there are no bail conditions set out or attached in respect of the matter in Court 8 cannot exonerate the applicant of such a duty not to abide by any form of conduct that is appropriate when he is so released on bail.
All right, apologies for that. We seem to be struggling with our audio and visual connection to the courtroom. We're still listening into the outcome of the bail application by Bhekumuzi Mike Sandlana. He is a leader of the faction of the International Pentecostal Holiness Church, accused of bribing High Court Judge Portia Phahlane. He's facing 9 counts of corruption and money laundering alongside Phahlane's son, Kagiso, and the church's spokesperson in Vusindala. These bribes apparently amount to about 2.4 million rand in payment and benefits, and it was all to try and essentially sway the judge in an ongoing and contentious court succession battle. It's a pity that there's a bit of an issue with the bail outcome, at least insofar as the audio is concerned, because we're still listening to, I suppose, some of the jurisprudence that has already been set before the judge actually delivers the outcome. I'm told we are able to continue listening in. Let's take you back there and continue following.
Very highly prevalent offences and serious ones, and not only a thorn within the jurisdiction of this court or an outcry, but it has created a general outcry, hence globally, and but in the Republic of South Africa, we are faced with a high level of corruption. I do not find, I should then find, based on the argument placed before court as to whether I'm persuaded that the applicant in this regard, under the consideration that I'm busy with, has shown the court that there is no likelihood from his part, taking all this into account, that he may conduct himself again in future in terms of what has been spelled out in terms of section 60 subsection 4a read with section 65, which determination I will have to make. And now in terms of section 60 subsection 6 of the Criminal Procedure Act, the factors that needs to be considered in respect of, in conjunction with the consideration under section 64b has been established as follows. A, the emotional, family, community or occupational ties of the accused to the place at which he or she is to be tried. B, the assets held by the accused and where such assets are situated. C, the means and travel documents held by the accused which may enable him or her to leave the country. D, the extent, if any, to which the accused can afford to forfeit the amount of bail which may be set. And E, the question whether the extradition of the accused could readily be effected should he flee across the borders of the Republic in an attempt to evade his or her trial. And F, the nature and the gravity of the charge on which the accused is to be tried. G, the strength of the case against the accused and the incentive that he or she may in consequence have to attempt to evade his or her trial. And H, the nature and gravity of the punishment which is likely to be imposed should the accused be convicted of the charges against him or her. And I, the binding effect and enforceability of bail conditions which may be imposed and the ease with which such conditions could be breached. Or J, any other factor which in the opinion of the court should be taken into account. In the founding affidavit of the applicant, it is not placed in dispute by, when regarding the founding affidavit of the applicant, it is not placed in dispute by the respondent to that he is a married person, a family man, and has got the minor children that I've placed on record in respect of their ages, and 6, 4, and 3, and that his addresses are mainly within the jurisdiction of the court There might just be an issue about the other address, which the court will outline. And he's now estranged from his wife through a pending divorce matter. And he's got other wives that he married by religious customs. The applicant indicated that he is not under any regular gainful employment, but he is a pastor, leader, comforter of the congregation, the IPHC, and there's also evidence that the family of the applicant is not destitute, as the applicant in Exhibit A indicated that he's in the main taken care of, that is financially, by the church, as aforementioned, and in some instances where he has to pay maintenance, as indicated on record, he borrows money from friends. That's what he placed on record. The applicant and wife, as evidence is placed on record, not in a harmonious relationship due to the divorce matter, and also there's also this pending matter in Court 8, Regional Court, Pretoria. The addresses that as furnished by the applicant are as placed on record in the founding affidavit, Exhibit A, Exhibit D, responding affidavit, and by that is authored, and Exhibit B is authored by the investigating officer, Colonel Schnell. The state placed argument in respect of the discrepancies pertaining to the address 128 or 248 Austral or Rabokala, also known as Jerusalem. And the evidence or the arguments of the state pertaining to what was also placed on record when the matter was postponed earlier in the proceedings that I've mentioned and the days thereof, where Mr. Monchani had to approach the accused and verify as to the actual address to be placed on record correctly. This leaves us with two addresses, that is the 128 and the 248 Oskral or Rabogala, but this is in the northwest region around Brits. The court's view would be that the two numbers, that is the 128 and 248, indeed cannot relate to the same premises. The defense argued that there is nothing sinister about a person moving from one place to another. As far as the community ties are concerned, it is not in dispute that the applicant is a pastor or leader or comforter of a faction of the IPHC, as abbreviated, a church with premises at Heidelberg and Northwest Ganana and Jerusalem, respectively. And in as far as his engagement with the community, as it is one factor to test his emotional, family, and community occupational ties within the Republic of South Africa. I've already mentioned that his involvement in the community, as he indicated in the annexure that whose photos were obtained on the 5th of December 2025. That is a date after the 3rd of December, after the matter was postponed. That is what he has deposed to in the affidavit, to say that he is a community builder in a way, my work, but that is his evidence as placed before this court. He also deposed to, in paragraph 11 of Exhibit A, about his funding of the 22 students who are studying at the Russian university and whom he accompanied around August 2025. He went to Russia and came back. The other addresses in Waterkloof Heights belonging to, that is one address belonging to Mr. Taba, is allegedly not the applicant's residential address.
All right, apologies again. We seem to really be struggling with our connection there to the Pretoria Specialised Commercial Crimes Court, where once again Bhekumuzi Mike Sandlana's bail application is being read out. He's the leader of a faction of the International Pentecostal Holiness Church and is facing 19 counts of corruption and money laundering for attempting to bribe a High Court judge in Portia Phahlane. In fact, Portia Phahlane's son, Kagiso, is a co-accused in the matter alongside the church's spokesperson in Vusindala. These allegations say, in fact, apparently the bribes amount to about 2.4 million rand in payments and benefits, and were all in order to sway the judge in an ongoing church succession battle. This is around, of course, the IPC itself, or the International Pentecostal Holiness Church. It doesn't seem that the connection is stabilizing, so what we'll do is try and get you the very latest as soon as we get it. The judge hasn't necessarily gotten to the substance of her ruling just yet. She's still really going through a lot of legalese and outlining some of the jurisprudence that is in place before finally coming out with the outcome of this particular bail application. You might be wondering where the co-accused are at. The matters have been separated because of a number of factors, including the fact that apparently Sandlana's address couldn't be verified when he initially made his own application. It's understood that police officers were also assaulted at the time of his arrest, and so the state has applied that his bail application be separated, I imagine because they want to add more charges versus, I suppose, some of these co-accused, who, as I mentioned, is Judge Portia Phahlane, her son Kagiso, as well as the church's spokesperson. We're going to attempt one more time to just take you back in and listen for that bail application as the outcome is being delivered.
Applicant, as he has indicated, the immovable properties, they are enlisted on record, as I do not want to belabor the record with that. But he also gave the version about his movable property, which he estimated to be at an amount of 300,000 rands, and without stating elaborately as to explain the nature of the property and as to where it is located, but it is furniture and some belongings pertaining to the applicant. One should assume that the value given in respect of all the estimated amount relates to the immovable property that the applicant has placed before court. His travel documents, there's been a debate about the passports of the applicant. He produced an original passport which I perused to indicate that he traveled to Russia, as alluded to, from the 14th of August to the 25th of August 2025, and the passport was issued in 2024. The traveling was not opposed by the state, as it has been argued on behalf of the applicant, and there were also no bail conditions attached in the matter that is in Court 8, Regional Court Pretoria. The applicant for the first time indicated in Exhibit D that 2 passports were issued, and he further indicated that the other passport was kept by the investigating officer who's related to the Court 8 Regional Court matter. His travel to Lesotho, as indicated in Exhibit B of Lieutenant Colonel Schnell, the applicant had denied to have traveled to Lesotho without a passport being checked, as indicated by the investigating officer, and he argued that the state failed to prove that. The state, in reply, submitted to the court that the applicant had a duty to produce the passport to the court. As he's the one who indicated that he traveled and denied to have traveled without the authorities checking on his passport. I accept that from the Court 8 documents as presented before this court, there is no evidence to suggest that the applicant evaded trial. The seriousness of the offences, it has already been placed on record that the offences against the applicant of corruption should be regarded as very serious offences, and that the punishment that would likely be meted out in case of a conviction would be very harsh a sentence in respect of just pointing out in respect of count 17, it attracts a minimum sentence of 15 years in case of a first offender. Count 17 relates to the amounts that I will summarize in respect of what has been indicated in the preamble to the charge sheet, and as well as the affidavit of the first accused, Mr. Tshepo Phuti. It relates to an amount of 2 million rands, again 200,000 rands and 400,000 rands, which were paid into a conveyancer's trust account in favor of accused number 4's purchase of immovable property and in relation to other costs that related to conveyancing. So just to show that the amounts would fall under the minimum sentence legislation, section 51(2), Act 105 of 1997. In respect of the strength of the case for the prosecution, the defense argued that the state has no strong case, but mere allegations which are substantiated and some of which are argued to be hearsay evidence. In State versus Jonas, it's a 1998 volume 2 SACR, page 677 at page 679 H in brackets, it was held that the accused could adduce evidence acceptable to the court that the state case against him is non-existent or is subject to serious doubt. And in the decision of State versus Matebula, it's a 2010 volume 1 SACR, page 55 Supreme Court of Appeal, where it was also held that where the accused is faced with allegations that he has committed, in that instance, a Schedule 6 offense and does not make out a prima facie case of the prosecution's failing, there is no duty on the prosecution to present evidence in rebuttal. Even in Schedule 5, it is this court's view that the same principle applies. The strength of the state case is key to a determination by the court of other factors due to the reasoning that if there is no case at all against the applicant prima facie, the other factors would have to fall by the wayside. Whether offenses are serious, whether one is a flight risk or not, the starting point is as to whether we have a case before court against the applicant. I'm alert of the fact that I'm dealing with a bail application, not the trial of the matter, and that the trial court is the one that will dig deeper when evidence is presented to adjudicate and evaluate the evidence at the end where it is going to pronounce guilt. But at this stage, there is no pronouncement of guilt, but the court is bound to assess as to whether the strength of there is a strong case against the applicant or not, or there's a case at all, prima facie, as the matter stands. It is easy to recommend stringent measures, which is one of the guidelines that are given to courts, that where there are no serious disputes or concerns about an applicant in a bail matter, that he may be a flight risk or so, measures can be placed as conditions of bail in order to secure his attendance in future. However, the degree to which they would be enforceable or be complied with may not be practicable in the situation of an applicant who shows disregard to the law. In terms of section 67, now considering whether the ground in subsection 4(c) has been established, the court, where applicable, take into account the following factors, namely, A, the fact that the accused is familiar with the identity of witnesses and with the evidence which they may bring against him or her, and B, whether the witnesses have already made statements and agreed to testify, C, whether the investigation against the accused has already been completed, D, the relationship of the accused with the various witnesses and the extent to which they could be influenced or intimidated. E, how effective and enforceable bail conditions prohibiting communication between the accused and witnesses are likely to be. F, whether the accused has access to evidentiary material which is to be presented at his or her trial. And G, the ease with which evidentiary material could be concealed or destroyed. Or F, any other factor which, in the opinion of the court, should be taken into account. This aspect has been dealt with fully, and I choose not to belabor the record other than to say that there is evidence presented from the first accused affidavit, Mr. Tshepo Mputi, indicative of the fact that he alleged that he has been threatened by the applicant, as he knows much about his unlawful activities, as also supported by the allegations in the charge sheet. The state indicated that they had not obtained themselves Mr. Puti's statement, nor spoken to him about the possibility of being a witness. That evidence has shown that Mr. Puti has been a member of the church of the applicant and others as well who made statements as victims of violence and threats, including the submissions made in respect of the estranged wife of the applicant. Those people are thus known to the applicant. They are within the circles of the applicant. In respect of F and G factors above, one is reminded to say that the evidence of Mr. Puti, again accused number 1, indicates that the applicant has access to a variety of persons within the sphere of government. For instance, Home Affairs, the Justice Department, as indicated from the perusal of the charge sheet and the preamble thereto, who are officers of court to the charge sheet. And the court would highlight to place on record that Mr. Mputi's affidavit outlines clearly and it tallies with the allegations in the preamble to the charge sheet that explains what the actual charges are against the applicant before court. Within the Department of Justice in the High Court, the matter allegedly started where the applicant approached one Morongwa Malepe in order for him to approach accused number 4, Miss Phahlane, Miss Dipuo Phahlane, who's accused number 4 in this matter. And that resulted in several gratifications, a series of gratifications, then being channeled through this Morongwa Malepe from the applicant to accused number 4 and to Morongwa as well. So this is to indicate and show the fact that there are people who are mentioned in the preamble to the charge sheet, also that tallies with what Mr. Puti had indicated in his affidavits and had indicated his fear for life in respect of the threats leveled against him. But the factor that I'm determining here under F and G is to what extent can the applicant be able to access evidence and to also have communication with other potential witnesses in a case. And I had to place this on record. In terms of section 60, subsection 8, in considering whether the ground in subsection 4 has been established, the court may, where applicable, take into account the following factors, namely A, the fact that the accused, knowing it to be false, supplied false information at the time of his or her arrest or during the bail proceedings. B, whether the accused is in custody on other charges or whether the accused is on parole. And C, any previous failure on the part of the accused to comply with bail conditions or any indication that he or she will not comply with any bail conditions. Or D, any other factor which in the opinion of the court should be taken into account. The issue of the identity documents of the applicant bears reference here as outlined in his Exhibit A affidavit, the Exhibit B of the respondents, pages 184 to 200. When perusing this pages 184 to 200, it's like a complicated affair for one to comprehend. The applicant's version is a bare denial of the identity issued in 1969, but he also avers that his birth date was registered by the grandparents, and hence his year of birth being reflected as 1966. In the aforementioned documents in Exhibit B, it shows that Home Affairs documents reflects the year 1969 on page 184 in the name Sandlana Bekum Gilbert, and date of birth 1969 0228. The latter numerical that formulates the 28, that is the 8 thereof, has been changed in pen from 9 to 8. The date 29 does not tally with the leap year calendar scenario of that year. What inference then should be drawn? The inference to be drawn is that it was inevitable then to tamper with the numerical at the end. The application for the change of year from 1966 to 1961 also reflects strange tendencies. On page 185, the abridged Bukutatswana birth certificate with number B281618 with the name Sandlana Bhekumuzi Mike Gilbert. The date of birth is the 15th February 1966. District Moretele, Zulu, with date stamp 27/03/1981. On page 191, the same serial number B281618, an abridged Bukutatswana birth certificate with the names Sandlana Bhekumuzi Mike Gilbert. The date of birth 15 February 1961. Male Zulu, Moretele District. The same date stamp 27/03/1981. There's a certification stamp here, visible as opposed to the previous one. It's 2010/08/17. The Department of Home Affairs date stamp is the 27th of August 2010, is the same date as the certification stamp. The applicant, as the state argued, blames the Department of Home Affairs, but the two birth certificates were submitted by him as it appears in his application for change of birth date. The only inference I'm entitled to draw from objective analysis of the facts is that the whole transaction of the change, as the state argued above, is fraudulent. Ms. Ndlovu, the Home Affairs official in SLR 7, paragraph 9, says the following: analysis on birth certificates seems to have been tampered with through serial numbers. Those serial numbers are the same. Investigations, however, are still on. The applicant has his ID number, which he alleges it was in respect of the date of birth for a long time, and wants to persuade this court that this is the true state of affairs, that he stayed with this wrong date in respect of birth and did not apply for change timeously. Another disturbing issue is the events surrounding the arrest of the applicant, which I said I would come or revert to the discrepancies. It is not in dispute that a scuffle ensued at Heidelberg, Ganana on the day of his arrest. He personally mentioned, that is the applicant, that he drove either from Pretoria, Ravugala, Oskra, upon being informed of the said scuffle. He denied having been in the premises of the church when the alleged attack against the police took place. He mentioned that he was alerted of the fact, then drove from the areas as I've indicated. Evidence was not placed on record as to the identity of the victims of the alleged assault and to what extent, but as mentioned above, that a scuffle ensued is not denied, as the applicant himself mentioned that he was called and had to drive to the place. However, Exhibit B, annexures LRS 11 and 12, shows that he was in the premises or in the vicinity of the church. The cell phone tower records proves that there was cell phone communication between the investigating officer, Lieutenant Colonel Schnell, and the applicant within the time also mentioned in the above exhibits. The denial by the applicant of having been in the premises of the church should be evaluated as to what then to believe in the circumstances. He barely denies that he was in the premises, and he says that he was called and he was driving towards the place, and a report was made that there was a scuffle between the police who came in to effect an arrest and, on the other hand, members of the congregation or the church. So that scuffle is not denied. The inference that one can draw, because nothing is said against LRS 11 and 12 and is not being gainsaid or challenged, it means that the applicant, the court should believe and arrive at a conclusion that indeed he was within the premises and he did not want to be arrested at that particular juncture. And this allegation from him that he was not in the premises but driving from Pretoria or Rabugala or Ostra, it's a falsity as well. In my view, a final nail to the coffin is what had been revealed to the court in Exhibit C, in the respondent's supplementary affidavit. I refer in particular to the annexed founding affidavit of the applicant addressed to the High Court, Gauteng North Pretoria Division, duly commissioned and signed by the applicant. And on top of, I think the date is the 30th of November. On top of page 8, the applicant address. The first respondent is the regional magistrate for the District of Pretoria, as the functionary who exercised her judicial powers and remanded my case, wherein I appeared along with 3 other co-accused, and who exceptionally denied my release on bail. The matter was remanded to 3/12/2025, 3 December 2025. In my introductory remarks, it is still clear that I mentioned that the applicant appeared with the 3 other co-accused as aforementioned in his application, and his application was not heard on the 26th of November 2025, when I granted bail in favor of his other co-accused, because I granted a postponement in favor of the state being the respondents in terms of Section 50, subsection 6 of the Criminal Procedure Act 51 of 1977, for the state to investigate the issues that I duly outlined already on record. In addition of the reason that I postponed the matter in terms of Section 56 for investigations, the very same date of the 3rd of December 2025 was allocated for the bail application of the applicant. One should remember that earlier I mentioned that Mr. Monjani, who's the instructing attorney here, mentioned to the court that he is ready on the 26th of November to proceed with the bail application. And because of the granting of the postponement to allow the state to investigate, the matter was then postponed to the 3rd of December 2025. As the investigating officer also submitted that surprisingly on the 3rd of December 2025, the applicant's legal team was not ready to pursue the bail application. And this is set against that background of what happened on the 26th of November 2025, when the defense objected to a postponement and indicated that they are ready to proceed with the bail application. On the other hand, the applicant had filed that urgent application for bail in the High Court on medical grounds. The record will also state that on the 3rd of December 2025, a date wherein his opposed application had to be heard, there was no mention made of the alleged medical condition that landed him in the High Court. The court has now to sit and evaluate and conclude about the conduct of the applicant in the circumstances, as to whether the court should conclude that the applicant managed to show that the interest of justice permits his release under those circumstances. Another discrepancy was pointed out by the state in respect of the date of the alleged illness being the 27th of November 2025, 27 November 2025 from the applicant's affidavit, where he explained that he get complications as he was feeling nauseous. He avoided eating, but lately couldn't succumb to avoiding the meals from prison. Then he ate and got complicated, amongst others, that he suffered shortness of breath and he had to be resuscitated, and the evidence is there on record. But his medical practitioner, Dr. Aluwani Confidence Sebata, through his affidavit, as also presented before court through Exhibit D, informs court that it was on the 28th of November 2025 when the ailment came in to attack the applicant. And she deposed to this affidavit to recommend the release of the applicant from detention, and gave reasoning to indicate the magnitude of the applicant's health condition that may not be maintained or monitored properly by the health facilities in prison. And she further indicated that she could not obtain any report from the prison hospital officials, as they needed authority first from their seniors before they can issue such reports. She, however, in her affidavit indicated that according to her, the applicant was brought and being supported by a prison warder when she came to the foyer, or to the place where she and the family members were gathered to awaiting to see him. However, there's no evidence presented from any of the family members who were gathered and came to see the applicant about her health condition, as at the time they paid a visit to him. Applicant indicated that the family and church members got counsel to bring an application to the High Court. Apparently, he could not get hold of his attorneys of record. Interesting, however, is the fact that the application was prepared as per notice of motion by one attorney, Ramotwala, who the record informs that he is a co-accused to the applicant in the Regional Court 8 matter. The application was apparently abandoned for want of compliance with requirements in the High Court. The investigating officer herein, who through Exhibit C informed court that he was not informed or cited in the notice of motion, upon being alerted by the prosecutor, maybe one of the prosecutor handling the matter, he did not identify who also was not duly informed, but was told by the other lawyers who handled the urgent bail application, went, upon being alerted of this fact, to the registrar of the High Court in Pretoria and obtained these documents which are duly filed before this court in this bail application. Finally, it is not disputed from the side of the court that the applicant, whilst released on bail and from the parties, that whilst the applicant was released on bail in the pending matter of court number 8, the regional court in Pretoria, then he allegedly committed the series of corruption offences as placed on record. I move to section 68, capital A, which facilitates my consideration of the grounds in subsection 4E, whether they've been established. I should look at the following factors. A, whether the nature of the offense or the circumstances under which the offense was committed is likely to induce a sense of shock or outrage in the community where the offense was committed. B, whether the shock or outrage of the community might lead to public disorder if the accused is released. C, whether the safety of the accused might be jeopardized by his or her release. And D, whether the sense of peace and security amongst members of the public will be undermined or jeopardized by the release of the accused. And E, whether the release of the accused will undermine or jeopardize the public confidence in the criminal justice system. Or F, any other factor which in the opinion of the court should be taken into account. Section 68, capital A, enlists serious factors for the consideration of this court. Under the section, one can remark to say that all the parties before court are in agreement, as I've already been alluding to, that the offenses are very serious offenses. But in this particular instance, in considering these factors under section 68, capital A, the seriousness also is elevated by the fact that it is a high-profiled nature of a matter that is before court, for the reasons that will remain a historical event within the judiciary and legal fraternity. It was argued, however, on behalf of the applicant that his co-accused were treated differently by this court, as I would want to address that aspect, though allegedly involved in almost similar offenses. It means the court treated the other applicants not equally to what is expected by the applicant before court. The statement cannot be correct. The applicant factors are different, as I've been mentioning them in my judgment, and none of the other applicants' factors as deposed to in their affidavit related to what the applicant factors were, which were presented for my adjudication and consideration. The likelihood that the release of the applicant, based not only on the factors enlisted in this provision as I've read in, but also in the negative factors already shown relating to his conduct, should be carefully considered by the court. If I've got to go through all the factors that are mentioned in section 68, capital A, whether the nature of the offenses or circumstances under which the offense was committed is likely to induce a sense of shock or outrage in the community where the offense was committed. The preamble, the affidavit of Mr. Mputi, accused number 1, that I have summarily placed before this court, has already indicated, and my remark to say the offenses are not only serious, but they are of such a high profile that will remain in history. So that escalates the seriousness of the offense and how the general public would view the nature of the offense. And B, whether the shock or outrage of the community might lead to public disorder if the accused is released. When the court adjudicates a bail application, it evaluates the evidence holistically it has to look into the section 60 subsection 4 A to E as read with these specific factors which I've been outlining in dealing with all those other subsections A to E. So as to whether there would be public disorder, the court cannot guarantee or detect. There's no tool that assists the court in doing that. But the fact that I had also mentioned that the events surrounding the salient facts in this matter as to how the offenses were committed will remain historical in respect of not only the fraternities that I've mentioned, but globally and also countrywide. So the unity, I should say, will depend on the factors, whether they found them shocking, whether they are disturbing factors that surrounds them in the community. So that's how I can view B in the circumstances of section 68A. C, whether the safety of the accused might be jeopardized by his or her release. I have not had any evidence in the presentation of the application before court, the bail application, that there's any animosity or any person or any statement that has been presented to say the accused indicated that he was threatened by anyone. On the other hand, however, different from what the court should consider under C, I can make a finding that the accused is largely and religiously supported by the members of his church as a leader of the church, and he has got that support. And his safety, I believe, is guaranteed by the support that he is getting from the members of the congregation. D, whether the sense of peace and security among members of the public will be undermined or jeopardized by the release of the accused, should also be read with E, whether the release of the accused will undermine or jeopardize the public confidence in the criminal justice system. That determination the court makes after holistically considering all the factors that has been placed before it. The likelihood, I repeat, that the release of the applicant based not only on the factors enlisted in this provision, but also in the negative factors already shown of his conduct may jeopardize and undermine the peace and security of the public, invite public disturbance, and lastly, jeopardize the public confidence in the criminal justice system, including the bail system. Finally, section 60, subsection 9, in considering the question in subsection 4, the court shall decide the matter by weighing the interest of justice against the right of the accused to his or her personal freedom, and in particular the prejudice he or she is likely to suffer if he or she were to be detained in custody, taking into account, where applicable, the following factors, namely, A, the period for which the accused has already been in custody since his or her arrest, B, the probable period of detention until the disposal or conclusion of the trial, if the accused is not released on bail, C, the reason for any delay in the disposal or conclusion of the trial and any fault on the part of the accused with regard to such a delay, and D, any financial loss which the accused may suffer owing to his or her detention, E, any impediment to the preparation of the accused's defense or any delay in obtaining legal representation which may be brought about by the detention of the accused, F, the state of health of the accused, or G, any other factor which in the opinion of the court should be taken into account. A balancing act is lastly expected of a court in terms of this provision, section 60, in brackets 9 of the Criminal Procedure Act, which involves the weighing of the interest of justice against the right of the accused to his personal freedom, in particular the prejudice he is likely to suffer if he were to be detained further. Applicant was in detention from the 26th of November 2025. It's just about a month, in 2-3 days to come, that he would have expended. It's not yet a month, so a month would only be completed on the 26th of December. B, his co-accused matter is postponed to the 6th of March 2025 for further investigations. The state mentioned that there are still investigations to be done, amongst others, correctly so on record, arrest of other suspects, prejudice in respect of the absence of that would be suffered by the accused here is that he would have been removed from his family, his minor children, the members of the congregation, which factors are not undermined by this court, but the balancing act has, as aforementioned, should be a yardstick, a tool that would assist the court to deal with this aspect finally. I refer to Section 36 of Act 108 of 1996, Republic of South African Constitution Act, which allows the court to limit any of the rights that are enshrined in the Constitution. That would include also the right to freedom and security of a person, should there be any justification for the court to do that. The state of health of the applicant has been addressed fully, as I indicated. The nature and condition of health has been outlined in Exhibit A, his founding affidavit. There's also the affidavit of Dr. Sevata that also was filed in the record to advise the court of the condition. And the court would not want to underplay the ailment of the applicant. But in this regard, I can just mention that there is no evidence on record from the side of the facility where the applicant is an inmate of, where he's been housed, that is the prison, about whether they would not be able to deal with the ailments of the applicant. The application, as it is spelled out, is clear, the rights that were explained to the applicant earlier. He carries the onus to show the court that the interest of justice permits his release. So taking cognizance of the ailments of the applicant or his health condition, which I say I do not undermine. However, I should also mention that there is nothing that is being presented from prison to say the facility there cannot take care of the condition of health of the applicant. There is also no evidence presented that the minor children of the applicant would not be taken care of, especially by their parents, firstly, or the church, as he indicated that he is largely dependent on the church in as far as finances are concerned. There's also a physical element in respect of how children, especially the minor children, should be taken care of. So I have not had any evidence presented before this court, and I should accept, because if that was a crucial issue, it should have been mentioned in the evidence presented by the applicant before court. The court, in terms of the provisions of Section 28 of Act 108 of 1996, which is our constitution, and also guided by some decisions of court, the likes of State versus M, which is a 2007 volume 2 SACR, page 539 constitutional court decision. The other case is State versus Peterson. It's a 1998 volume 2 SACR, page 311 in bracket C. The latter having dealt with the issue of children, especially where a bail application is dealt with by the court. The court, in terms of these citations and decisions that I've placed on record, and the legislation, which is the umbrella legislation in our country, our constitution, as aforementioned, Section 28, burdens courts to dig much into the circumstances, home circumstances or personal circumstances of the minor children. But in the circumstances of this case, there is no evidence to suggest that those children are abandoned, especially in the scenario of the applicant as being the leader of the church, as aforementioned, having mentioned on record that the church also provides financially for him. That brings me, after a careful and cautious consideration of all the factors under subsection 9, 60 subsection 9, and the totality of the evidences presented before me, inclusive of section 12 and 35 of our Constitution Act that protects the right to freedom and security of persons, that is section 12, and 35(1) in respect of the rights to innocence and silence, and the rights under subsection F not to be detained arbitrarily, I arrive at the following conclusion. One, that I do not find that the applicant managed to discharge the onus solely placed on him to show this court on a balance of probabilities that the interest of justice permits his release. And secondly, I further find that if released, based on what I found, he is likely to pose as a flight risk, and references herein made to the ID documents evidence that escalates such a likelihood, and also towards evasion of trial. Thirdly, his past conduct overlapping to his current one in the application for bail revealed false evidence being presented before court. And fourthly, he displayed wanton disregard of the law through Exhibit C, his affidavit in respect of an urgent application to the High Court, Pretoria. And on the fifth end, there are deponents of affidavits, as duly mentioned by the court, presented here in this application, who have indicated clearly that there are threats leveled against them. If you could stand up, Mr. Sandlana. And in the premise, I make the following order. I dismiss the application of the applicant herein to be released on bail.
As the court please.
All right, at a minute before 11 o'clock, that's breaking news coming your way from the Pretoria Specialised Commercial Crimes Court, where Bhekumuzi Mike Sandlana, the leader of a faction of the International Pentecostal Holiness Church, has been denied bail. It was a very long outcome, with the judge first starting off by explaining some of the jurisprudence that is, I suppose, available insofar as this matter is concerned. She then went on to explain the circumstances surrounding this application and has now finally delivered her judgment. And she says that Mike Sandlana has not shown that it will be in the interest of justice that he be released on bail, and in fact is concerned that he may very well be a flight risk. The story, of course, is surrounding the claims that Mike Sandlana had paid a bribe, essentially, to High Court Judge Portia Phahlane in order to sway her outcome, or at least sway her thinking around a protracted succession battle. He's said to have paid millions of rand in the form of this bribe. In fact, the exact figures are approximately 2.4 million rand in payments and benefits that were made between 2021 and 2022. In fact, prosecutors claim that, as I mentioned, this was to secure a favourable outcome from Judge Portia Phahlane in that IPHC succession dispute. It's also been alleged during his bail hearing that Sandlana had actually instructed attorneys to bribe the former Judge President of the Western Cape, in John Hlophe, in yet another case. The reason why he's appearing alone and not with his co-accused is because essentially we learned that when he was being arrested, officers were allegedly assaulted. The state has also struggled to prove the address that he has provided, or at least to verify it. And so I suppose several other charges will be added to the 19 counts of corruption and money laundering that he is currently facing. As soon as we get any more information about the way forward, we'll certainly bring that to you here on the SABC News channel. But the breaking news at this hour is that Mike Sandlana, the leader of a faction of the International Pentecostal Holiness Church, has been denied bail.